West Legal Ed Center and Celeste welcome you to today's program titled H1b Season is Back, an informative session on the H1b 2022 to 2023 updates and filing process. Use the Participation tab at the bottom of your screen to send a question to the speakers. Program materials are available under the Supplements tab. It's my pleasure to introduce our speakers for today's program, David Nachman, Ludka Zimovek, and Snehal Batra. Thank you for joining us today. I'll now turn the program over to Mr. Nachman.
Thank you very much, Len, and it's a pleasure to be here, and thank you all for attending today's CLE on H1B and the new filing season. If I sound like I'm a little out of breath, it's because we're in the middle of the H1B 2023 filing season at this very moment, and we're hoping to provide you with some interesting news and updates, and also hopefully whetting your appetites with regard to what the H1B lottery is all about and potential opportunities for H1B workarounds, because H1B lottery is a chance. It's just like buying a lottery ticket any day of the week. What can you do to avoid the lottery and bring exceptional specialized talent to the United States to work for your organization or your clients' organizations? So my name is David Nachman. I've been practicing immigration law for 30 years. Our office, the NPZ Law Group, specializes only in immigration and nationality law. That's all we do. And we do a full spectrum of practice out of our offices in northern New Jersey and central New Jersey, and affiliated offices in Canada and India. With that, I'll introduce you to my law partner, Ludka Zimovek. And Ludka, take it away.
Thank you very much, David. My name is Ludka Zimovek. Same as David, I've been practicing immigration and nationality law for a while, for over 15 years. I personally handle employment-based immigration, family-based immigration, some asylums, removal proceedings. So as David mentioned, we handle all aspects of immigration law. And I look forward to speaking to you today about the H1B seasons. It's really hot issue right now. Snehal?
Thank you, Ludka. I'm Snehal Batra, one of the attorneys at NPZ Law Group. I've been in practice for 20 years now, and for a majority of that time, my practice has been focused on U.S. immigration, and I too handle employment and family law cases, family-based immigration cases. And we're excited to talk to you today about what the H-1B lottery is, how to get in it, how it all works, and if your client does not win the lottery, what options they might have. So with that, why don't we get started?
Thanks so much. Thanks so much, Snehal. So we work in a collaborative environment because this stuff is complex. And also, there's a lot of information out there that many of you may be tapping into. If you're interested in the H-1B arena, you're probably online and trying to gather information. Maybe some people in your organization or your clients have come to you and asked about this H-1B space. And what we're hoping to do is sort of dispel any preconceived notions about H-1Bs that may not be true, and to guide you on what the really good resources are that are out there. Obviously, it's an area, immigration and nationality law in the United States is an area that changes fast and furious. And some of the more recent changes, which we want to bring to your attention, is that the Biden administration sent a message by way of passing new regulations that we want to attract the best and the brightest to the United States. We don't want to just train people here as international students. We want to find a way to keep them here. And the normal route that a person would take, which we'll delve into with a little more specificity as we go, is that an international student may be trained here in a science, technology, engineering, or mathematics major, and then they have to do an H-1B non-immigrant work visa to be able to stay longer. and then they look to the green card. So some of the things that this new administration, the Biden-Harris administration, has done to make things a little easier is that they have passed new regulations to allow for academic training for STEM J1s, which are J1s are individuals who are students and researchers, research scholars. So now they can train in the United States up to 36 months. So that keeps them here. There also are special programs that are available for STEM research that you can take a look at if you're interested on the U.S. Department of State website at travel.state.gov. And those programs are going to be afforded a more liberal interpretation, and obviously maybe even be easier for individuals to apply at U.S. consulate offices abroad for those programs that deal with STEM. There was also an expansion of STEM majors in universities throughout the United States. In fact, 22 new STEM majors have been announced. And the importance of that is that by announcing these new STEM majors, this means that international students have an opportunity now to get an additional 24 months of work in the United States. So ordinarily, an international student who's working in the United States gets 1 full year of what's called optional practical training. And many of you may have seen or be familiar with an employment authorization document that an international student may show, which gives them 1 full year, 12 months of OPT. But if they're in a STEM major and the employer is in the E-Verify program, that employer is able to offer them an additional 24 months of work, which is valuable because then what that does is it allows the individual, the international student, to be able to go into multiple H-1B cycles or H-1B lotteries. And the reason that that's important is because, again, it's a lottery. So the more they go into, the more cycles they go into, the more the possibility that they're going to be able to get an H-1B. And of course, the value of having an H-1B will be, we're going to discuss that as the program continues. In addition, the new administration also focused on liberalizing the types of evidence that are required for O1s, which are individuals who are extraordinary in the arts, the sciences, and business. So there is a subsection of that, of those regs that say that you have to show comparable evidence. So the liberalization of comparable evidence to be able to get an O1A is something that was recently announced, as well as the liberalization of comparable evidence for getting a green card, which is through a self-sponsoring category as through the national interest waiver classification. So national interest waivers can either be done by the employer through sponsorship or directly by the employee. So it's kind of exciting to see that our administration is focused on the importance of maintaining the best and the brightest, getting them here and keeping them here, because I believe that it's clear from consulting reports that have been commissioned by the government that these folks are renewing and continuing the entrepreneurial spirit here in the United States, and also clearly adding to the economic infrastructure. So, these are some of the new exciting developments. Thank you so much for that. And so what we're going to do is we're going to move on to just quickly tell everyone a little bit about how the U.S. immigration and nationality law system is designed, because it's important for everyone who's on this webinar to sort of understand the steps that an individual needs to take to go through. It's sort of a spectrum that goes from sort of the left to the right, where we have various categories. The first category is individuals who don't have any status at all. Then we have a category called non-immigrants, and we'll explain non-immigrants to you. Then you have individuals who are immigrants or green cards or lawful permanent residents. And finally, you have naturalization, and that is an individual who is a United States citizen. So many folks who are foreign nationals aspire ultimately to become citizens, but a lot of them may not necessarily want to be citizens, and we'll describe that in a little more detail. But first, let's talk about people who don't have any status in the United States. And so there are a variety. You would think that individuals who are in the United States have no status, don't have any options, but that's not in fact the case at all. Individuals who are in the U.S. who don't have status do have some options, and a few of them are as follows. One is there's a program called DACA. DACA is Deferred Action for Childhood Arrivals, referred to as the Dreamers. These are individuals who have been brought to the United States and really probably don't even know their home countries. And this was developed by the Obama administration and implemented as an executive action. And President Obama sort of announced that individuals who qualify for DACA can remain in the United States, get work authorization. As many of you who are on this webinar may be aware, that program was under tremendous fire during the Trump administration, actually ended up at the Supreme Court, and the Supreme Court kicked it back for rulemaking because the Trump administration had allegedly taken this program offline in violation of the Administrative Procedures Act. So DACA is alive, and it's actually out for rule. It was under the rulemaking process, and actually I think that just a couple of weeks ago the rulemaking period closed, and we are now waiting for a final rule on DACA to be promulgated. The next benefit that may be available to individuals who don't have status is the U visa. U visas are for victims of certain crimes. There's a list of crimes that is anywhere between, I would say, 12 to 15 different types of crimes. And if an individual is in the United States without status, they can apply for a U visa if they are either a victim or working with law enforcement to root out the evils of the world. So that's the U visa. Another benefit that might be available to individuals who don't have status in the United States is 245I. 245I was implemented under the Clinton administration. That program was called the Life Act. And basically what that says is that if an individual had made a qualified filing, and a qualified filing is defined in the law, for example, an I-130, an I-140, or certain other types of benefits, then the individual, if they made that qualified filing, can pay a penalty to the government and adjust their status in the United States and stay without having to depart. Of course, the downside of departing is that if you do depart and you've accrued 180 days of unlawful presence, then you are barred for 3 years. And if you leave after accruing 365 days of unlawful presence, you're barred for 10 years. So the 3 and the 10-year bar is really the bane of a immigration lawyer's existence. And this is what Lutka and Snehal and I tried to do, is to find ways for our clients to circumvent the 3 and 10-year bar. Another benefit that might be available to individuals in the United States without status is asylum, where they have a credible fear of persecution and they have to demonstrate that they're a member of a particular social group. It's very important that this type of a benefit needs to be clearly articulated to an asylum officer. So that's sort of the discussion of the asylum type of case is sort of beyond the scope of today's presentation, but we just want to let you know that it is out there. Another benefit that's available to individuals who are out of status is marriage to a U.S. citizen. That's a family-based immigration. It's an immediate relative type of an application, but it is available to individuals who are in the United States who have entered with inspection, and they have an opportunity to marry a U.S. citizen. As long as it's a bona fide marriage, they have an opportunity to get status here in the U.S. So those are the categories that we wanted to just tell you about, because again, you would think individuals who are in the U.S. without any status at all, don't have options, but there are some options. But the ones that we're more particularly want to focus on today are non-immigrants and immigrants. And so what I'm going to do at this point is turn it over to Lutka and let Lutka describe the non-immigrant visa classification and the dichotomy between pure non-immigrants and dual intent non-immigrants, and why that is important for us as immigration lawyers. Lutka?
Thank you very much. So non-immigrants could be students, visitors, H1b holders, L1s, religious workers. So these are all different non-immigrant categories. And within non-immigrant visa categories, we do have those that have pure non-immigrant intent. A perfect example would be students or visitors, because when they come in, they have to show or demonstrate that they have strong ties to their home country and they're not planning to immigrate or stay permanently in the United States. Then we have dual intent visa status, and that's usually the one that applicants are looking for. Perfect example is the H1b, and we are going to be talking about the H1b. So pretty much typically you would have a client or applicant or employee who is coming and saying, I want to apply for the green card, or employer may come and say, I have this great employee on OPT holding F1 visa, and we would like to proceed with the green card. And this is exactly where we would take a step back and just review the resume and explain that the best approach would be first switch this individual into more long-term work status, dual intent status that would later allow them to apply for the green card as well. So H1B is a good example, L1 is a good example, R visa. Those are the typical dual intent visas. So once the individual has this type of long-term work status, then at any point they can move on to the immigrant side, which is either family-based immigration or it could be employment-based immigration. So employer can file green card for them, they can do self-petition, or a family relative can file a green card application. And once obviously they obtain the green card, at the last stage of the immigration process would be citizenship. Some people will just stay with the green card forever, and some after 5 years will apply for citizenship. If someone is married to U.S. citizen, it would be only 3-year wait time. But typically the process would be for most individuals, that's what we see the most, is the student applying for OPT, getting work permit, moving on to H1B, and later to a green card. So since the purpose of today is talking about H1Bs, Snehal, why don't you tell us about H1B and what H1B is?
Sure, thanks, Lutka. So the H-1B is a non-immigrant visa classification, and it does allow for dual intent, as Lutka mentioned. It's a visa for professional individuals who are looking to work in a professional position in the U.S. So it is specifically for those individuals that have the equivalent of a U.S. bachelor's degree. And the position has to require at least a minimum of a bachelor's degree to enter that profession. So for a U.S. employer looking to hire a foreign national, you can potentially qualify for an H-1B if the job is one that requires a minimum of a bachelor's in a specific field and the individual has the equivalent of a bachelor's. So you can have a foreign national that has a foreign degree, okay? So if your potential employee completed a degree, a bachelor's degree back in their home country, as long as that degree is the equivalent of a U.S. bachelor's degree, the individual would qualify for the H-1B. Now, sometimes a foreign national may have less than a bachelor's degree. They may have completed a partial degree program, but have work experience. The nice thing is under the H-1B regulations, what we know as the 3-for-1 rule, for every 3 years of work experience, you can substitute 1 year of academic study. So an individual may actually have the equivalent of a U.S. bachelor's degree based on a combination of their college education plus work experience. Now, this particular type of evaluation or assessment is not done by the attorney. Okay, so keep in mind that your employee might qualify, but it's not the attorney that makes that determination. It's an agency, an outside academic evaluation agency that would look at the specific credentials of the foreign national to determine whether or not it is in fact the equivalent of a U.S. bachelor's degree. So if you have that, then potentially the individual is eligible for the H-1B and can go into the lottery. Some examples of specialty occupations or H-1B positions that are specifically included in the regulations include a chemist, an engineer, biologist, an accountant, lawyers, graphic designers. But even if it's not in the regulation, if the employer can argue that for this particular role, a bachelor's degree is normally required, then the position could be deemed a specialty occupation for the purposes of the H-1B. Ludka, do you want to talk a little bit about who should be applying for the H-1B cap season?
So right now, obviously, is the H-1B season, and everyone is contacting us and all the attorneys about H-1Bs. Or we would instruct employers to review, who the immigration, those foreign nationals that may need H-1B sponsorship. So definitely students that are holding OPT. So this is the category that, would be probably one of the first to think about. Then there may be people, I see a lot of students having internships. So even though they didn't complete their studies, but they may have a bachelor's degree, an employer may be interested in doing the H-1B early on because of the lottery. TN holders, so if there is a plan with green card, for example, so the employee is planning or the employer is planning to proceed with the green card because TN is not a dual intent visa status, it's always a good idea to proceed or switch this person over to H-1B. Then there is a category of dependents. So employer may have workers that hold H-4s, L-2s, E-2s, so different type of dependents. Also L-1s and L-1Bs. There could be whatever reason, for example, if the person is from India or China, retrogressed category, and they will need more time. Oftentimes we see switching over from L to H-1B. So these are just some examples of applicants that should be considered for the H-1B, and of course early on because it is a lottery. David, I have a question for you that we often see. Could there be multiple employers?
Absolutely. Absolutely, Luke. In fact, not only, I think what you're saying is, can multiple employers do registration for potential H-1Bs? And the answer there is yes, they can. However, they have to be very careful to ensure that there is no relationship between the organizations, because if there is a relationship, then the government may say that the system is being gamed, and if the system is being gamed, then those H-1Bs can be disqualified. So employers have to be kind of clear about the fact that there's no relationship between them. Ludka, I'd like to take a step backward, if you don't mind, and actually back to that slide on specialty occupations where we have examples. And I just want to quickly point out that there are various ways in which to help determine whether or not an individual is or is not a professional and serving in a specialty occupation. And so one of the resources that we as lawyers would use, and we encourage our colleagues who are doing this type of work to pre-screen to determine whether or not there is or is not a professional position, is to look at the Dictionary of Occupational Titles, which is one particular resource that's published by the U.S. Department of Labor. Also, there's the Occupational Outlook Handbook, that's a sister publication from the U.S. Department of Labor. And what the U.S. Department of Labor has done is established SVP, or specific vocational preparation codes. If there is a SVP in excess of 7, that is considered to be professional. So that would be a way to prove that a particular position is professional. Also, there's something called ONET that's available online where they have job zones. And if you have a job zone of 4 or greater, that's considered to be professional. So these are ways in which our colleagues would be able to sort of pre-screen if an inquiry is made to determine whether or not a position is or is not going to be professional within an organization. So for example, if an individual comes to you, let's say from a restaurant, and it's a cashier at a restaurant, is that considered to be a professional position? Probably not. That wouldn't be a professional position. But if you have a financial person who's, let's say, handling the finances for multiple restaurants or even a group of restaurants, that may be considered a professional position. So that's sort of the difference. So, but more importantly, let's move right along to the next slide, which talks a little bit about the H-1b process itself. And so let's tell the webinar attendees about the process. Lutka?
Thank you so much. I'm just going to mention very quickly to explain why we have the H-1b lottery process, if anyone is wondering. So unfortunately, there are not enough H-1Bs, and we only have 65,000 H-1Bs annually. And then we have additional 20,000 for US master's level or higher. And because of that, we have lottery. Last year, there were over 300,000 applicants. So you do the math. The statistics are not the best. And because of that, for the past, if I remember correctly, since 2008 or 2009, we do have lottery. The good news is that we have new registration system or new lottery system. This is the 3rd season, so it's definitely easier than it used to be. In the past, we all had to file H-1Bs on April 1st. So now we have electronic H-1b registration, where the employer will register each beneficiary starting on March 1st and until March 18th. So we're almost at the end. And it's a $10 fee for each beneficiary. And by April 1st, we'll know results. And only those that are selected will be able to file the H-1B petition starting on April 1st up to June 30th. And then assuming that if there are any selected H-1B applicants that did not use the number, and that is usually put back into the pool of applicants. In the past 2 years, we had July lottery as well. And last year, we had November lottery as well. The good news is there is no registration needed for the July or November lottery. So the registration only happens once a year in March. So that's the process, which makes it much more easier because we don't have to do the full petition for every applicant. I'm sure that all employers welcome that news. And, just to repeat that the start date, it started on March 1st. It's until March 18th. So we still have 7 days left. And important thing is the H-1B start date, as far as the H-1B employment start date, is October 1st. So you always have to think about the status. Does the individual have a legal status? Do they maintain status up until October 1st? Because that's even H-1B, if it's approved, it will kick in on October 1st or later, depending on when the start date is. But the earliest would be October 1st. With students, it's pretty simple because we do have gap extension for most of them. It's more problematic for those with TNs or H4s where they have dates certain. And for example, if the status is expiring in July, then we have gap in status. And it's very important to find some type of gap filler up until October 1st. In alternative, the individual can go home and, we could do H-1B processing as a consular processing. And then that individual would pick up the H-1B visa at the consulate and return back earliest September 20th.
Before we go to the next slide, I have some compliance to just let everyone be aware of. In order to comply with New York regulations, Attorneys looking for CLE credit in New York will need to be able to provide a code. This code is not intended for the West legal education audience, either live or on demand. I will read this code twice and only twice, and cannot repeat it or email it to you. So please make a note of it. The New York State code is as follows. It is V as in Victor, S as in Sam, 3274-31022. Again, V as in Victor, S as in Sam, 3274-31022. Thank you. So, Snehal, tell us how long an H-1B is good for.
Sure, David. Generally, when the employer files the initial H-1B application, they can request for up to 3 years of H-1B stay. Then the employer is eligible to extend for another 3 years. So you have a total of 6 years in H-1B stay. And any time that the employee spent outside the United States is not counted towards that 6 years. So we can recapture that unused time beyond the 6 years if we need to extend the employee's H-1B visa. Now, there are some exceptions where some H-1B visa holders are eligible to extend beyond the 6 years, okay? And that happens when the H-1B has had their green card process started at least 365 days prior to that 6-year max out period. So if the perm application has been filed in year 5 and is pending, then the employer can request a 1-year increment. Same thing, if we have an I-140 approval, then we can request a 1-year extension. Now, with those foreign nationals that are subject to the backlog, so our clients from India and from China who may be, waiting a really long time for their green card paperwork because of the backlog, they're actually eligible to extend in 3-year increments. So it's quite possible that you might have an H-1B employee that's in the U.S. for, more than 6 years. It could be going on year 8, year 9, year 10. That's not actually that unusual. I'll also just talk briefly about the H-1B as it pertains to the employer. So the H-1B is employer specific. That means that the foreign national is only eligible to work for that H-1B employer that filed the application for them. However, concurrent H-1Bs are permitted. That means if the foreign national wants to work for another company, because they have already secured an H-1B and counted towards the cap, they don't have to go back in the lottery, and the new or additional employer can then file the H-1B. So they can hold 2 jobs. They can have the part-time job, they can have the full-time job, and part-time job could be as little as 8 or 10 hours a week. That's also permitted. There's no magic number for that. H-1Bs are also portable, and what that means is the H-1B foreign national can transfer or change jobs as long as the H-1B, the new employer, files an H-1B transfer application. And when they file that application to port to a new employer, the H-1B employee is eligible to begin working when the application for transfer is received by the Immigration Service. So that's a nice thing that's available. And part-time employment is also permitted, and I just mentioned that with a concurrent. But the H-1B, even if the employee is filing with one employer going into the H-1b registration, the offer of employment can be part-time. It doesn't have to be full-time. And by going in with the part-time employment does not decrease your chances, okay? It's still the same lottery. So that wouldn't hurt your chances of being selected.
So Snehal, I have a question. Is there a limit on the number of concurrent H-1B visas that an individual can have?
No, there's no limit as long as the employee has the offer of employment and the H-1B employer is willing to file. and pay the wage. And we'll talk a little bit more down, in this webinar about the wage issue. But as long as the employer has the ability to pay that, there's no limit.
Exactly. And how about on the number of hours for a part-time H-1B? Is there any limit on that?
No, not at all.
Great. Thank you. Perfect. So actually, there is a cap on the number of H-1Bs that are available, and this is why it's a lottery system. 65,000 are available for an individual who has the equivalence of a U.S. baccalaureate degree. There's also an additional 20,000 available for individuals who have U.S. advanced degrees. Those advanced degrees have to be from organizations that are higher education organizations that are not for profit. So you have to be kind of careful when you're putting people into what we refer to as the master's cap for the 20,000, because you have to make sure that they are not for profit academic organizations. Last year, the cap was met with a total of 308,000 registrations. This year, we anticipate that there probably will be more. We're in the middle, as we said before, of H-1B season right now. The filings will end on March 18th, as Lutka pointed out, and they will run the lottery between March 18th and the end of March. And then we will be gearing up for H-1B petition filings after April 1st, again, requesting an October 1st start date. The great thing that we found is that about 48% of the registrations were individuals with advanced degrees. So obviously, again, going back to the fact that this program is about attracting and maintaining the best and the brightest in the world here in the United States, that seems to be the goal that's being achieved. So one of the things that obviously, because it's a lottery, we want to try to think of ways that we can possibly get our clients out of the lottery system and to be able to get an H-1B. So we work to try to find exemptions or workarounds. So one of those opportunities is that doing an H-1B for a person who has an H-1B and H-1B transfer is one exemption from the H-1B cap. But Lutka, what other exemptions exist for getting folks out of this H-1B lottery?
So whenever the applicant is going to be working for academia, so it's a college or university, higher education, they're not subject, these organizations are not subject to the numerical limitation. There is no deadline for the H-1B. So again, those going into academia, it's not an issue. They can file, the employers can file the H-1B in January, in July, whenever. So, there is no issue, and those applicants don't have to worry about any deadline or any lottery. Then we have organizations that are nonprofit organizations, 501c3 organizations that do research. So it's a research organization. What we see oftentimes that those organizations themselves, unless they have done H-1B, they don't even know they're a cap exempt organization. And oftentimes we have to review bylaws and website and other supporting documents to see whether we can make an argument for cap exemption. Then there are also organizations that are affiliated. So it's always a good idea to ask questions about affiliation agreements, because, for example, hospital, oftentimes, they're affiliated with university. So that would make them cap exempt organization. So these are just some things to watch for if an employer comes. So for example, if the employer is reaching out, we have now one employer who is a nonprofit, and they do some type of research, but they decided because we are in an H-1B season, they are going to try lottery. If the applicant is not going to be selected, at that point, we are going to be doing cap exempt H-1B later on, because obviously there is no deadline.
And for employers who might be in this webinar, or for lawyers who represent employers who are looking for a way around the H-1B lottery, there are things called incubators, and incubators are prominent on the campuses of many universities and colleges across the country. And if individuals are working in those incubators, that might, because affiliation agreements are closely tied to incubators, that might give them an opportunity to be able to circumvent the H-1B lottery and to be able to hire these very highly skilled workers anytime during the year. So the next slide is about the labor condition application. And the labor condition application has to do with the fact that employers have an obligation to ensure that the individuals that they hire, number one, that there's a posting that is done, the Department of Labor requires. Number two is that there is an attestation that they are not displacing U.S. workers. And three is that they're going to pay them the federally mandated prevailing wage. So this is one of the obligations that an employer has. These are several of the obligations that an employer has if they're going to be doing an H-1B. And I believe there's also something called the public access file. Snehal, can you explain to the folks who are on this webinar what a public access file is?
Sure. The public access file is basically a set of documents that the employer has to put together and have available on day one of filing the LCA for public inspection. So part of the LCA, the labor condition application, as David mentioned, these are promises the employer is making. And so in addition to that, they have to keep all of this documentation and make it available. And so the public access file has information pertaining to the LCA, how they calculated the prevailing wage, explanation of all of the benefits that they're going to make available for the H-1B foreign national, and also the copy of the posting, where the posting was placed for the days, and then also proof that they provided the certified LCA to the foreign worker before they start their H-1B employment. This particular public access file is not part of the employee's employment file, okay? It's separate and apart from the HR file. And they have to, the employer should not mix the public access file together with the human resource file, because in the event of a site inspection or an investigation, you don't want the government to have all this additional documentation that, is not part of the public access file. And it's important to note that you do have to update the public access file when there is a change in the corporate ownership or structure, if there's a change in the actual wage level, because the government wants to make sure that these changes do not displace U.S. workers, okay? And lastly, if there is an actual termination of the H-1B employee, that also has to be placed in the public access file.
So Ludka, one of the big things that the media talks about frequently is the fact that these H-1B non-immigrant workers are displacing U.S. workers because they're being paid less than the federally mandated prevailing wage. Is that true, or is that a falsity?
It's not true. Definitely.
And
not.
why?
Why? Because there is a prevailing wage that they have to be, employers actually have the obligation to pay a prevailing wage. We have certain levels, and employers are typically surprised that those wages, prevailing wages, are pretty high. We have level 1, 2, 3, 4. So we always, at least in our practice, we do a little chart when preparing the H-1B. We look at the actual requirements for the position. We look at what the employer is requesting. Based on that, the level is decided. And those prevailing wages are pretty high, and the employer has to be paying those prevailing wages to H-1B non-immigrants. They cannot just decide, now we don't have work, so you're gonna go to part-time. Any change needs to be reflected in amendment. So for example, if the individual is going from full-time to part-time, or is going to be, if, for example, there is salary is going to be lower for some reason, there needs to be an amendment, and there has to be a new LCA. If they change, for example, location, and now the individual is going to be working in California instead of New Jersey, there has to be an amendment. So employer does have a lot of obligations. The one thing that I want to point out that oftentimes we see actually on the news is for H-1B, we do not have to prove that there are no other US workers that are qualified to do the job. That's for the green card. And oftentimes that's kind of misleading because I hear from our clients or employers asking me this question. So I just want to point it out.
And Ludka, the point that you made about the individual moving and the need to amend is set forth in the Simeo Systems case, which if anyone needs the citation for that, please feel free to reach out, and we'll be more than happy to provide the citation for that case.
So it's any material change, pretty much. Any material change will require H-1B amendment.
Exactly. So obviously, the employer has several obligations that are associated with the H-1B process, and so what are some of those? Maybe we should just tick off what those obligations are. Number one, they have to do a posting. They have to have a public access file. This is required by the Department of Labor. They have to make these attestations. They have to offer return transportation if the relationship is terminated. And you have to pay the federally mandated prevailing wage, which is actually, we sort of, if we're drafting the H-1B, we sort of have control over what is the federally mandated prevailing wage. The Trump administration actually had a proposal online, which didn't actually go through, where what they were going to do is they were going to have the government establish the federally mandated prevailing wage. So, which is similar to the way it is right now in the perm labor certification process. So, so that's kind of interesting. Yes.
The employer also, you were talking about termination and offering the transport to pay for the transportation. It's important that the employer also notifies the government about the termination. That's very important, so they are not hooked, so they don't have issue with the back wages.
Exactly, and so the law seems to clearly state that sending a withdrawal notification to the USCIS to formally withdraw the H-1B is the way that termination takes place. Although there can be evidence of the fact that the relationship has been properly terminated, but that was a case that was litigated it was actually with the Department of Labor. It was a Pegasus case that was out of New Jersey Department of Labor. Human resource managers obviously play a little bit of a role in the H-1B process insofar as they're filling out the I-9 forms, probably for the organizations. And so I-9s have to be properly filled out for individuals who are in, as Luca described before, what's called cap gap protection, the period of time where an individual is allowed to work in their OPT through October 1st. While the H-1B process is going on. So you have to be familiar with what's called the M-274. The M-274 specifically has sections in it that deal with how to do a employment eligibility verification for individuals who are in the cap gap. It also explains how to properly do the I-9 form for individuals who are utilizing portability under Section 105 of AC 21, the American Competitiveness in the 21st Century Act. And also it's sort of a timely to bring up the fact that there are certain accommodations in place, at least until the end of April, with regard to remote workers in the workforce and doing I-9s remotely. So what if somebody doesn't win the H-1B lottery, Snehal? I mean, what do they do? What are the options that might be available?
Well, this is where, what our law firm does is take basically like a holistic approach where we'll be looking at all potential options for the foreign nationals as backup plans or alternatives. And we talked about some of them in the beginning of the program, some visa classifications. But one of the first things that we look at is, where is this foreign national from? Because if they're from certain countries like Australia, Mexico, or Canada, there are specific visas that are available, similar to the H-1B. For example, the E3 is for Australian nationals who are coming to perform specialty occupation work. The TN is a non-immigrant visa under NAFTA, which is now the USMCA. So if your foreign national is coming to work for a specific position that's listed under the appendix, the NAFTA appendix, they can come in as a TN. Also, the E2 is a nice, E1 or E2 is a nice alternative, and that visa classification is basically E1 is treaty trader, E2 is treaty investor, and these are for individuals that are either conducting substantial trade or investment in the U.S. that come from countries where their country and the U.S. have a treaty of friendship, navigation, or commerce that would allow them to be in the U.S., to work for that company. Now, that is a strict non-immigrant intent visa, so that's not the best option, but many times it's a really nice backup plan if you're not selected in the H-1B lottery. The L is another option, which Ludka mentioned earlier, which is the intercompany transfer, where the individual has to show they've been working outside the U.S. for 1 full year for a related organization before they can be transferred back into the U.S. So that could be a potential option if the employee wants to go back, or maybe perhaps was working for 1 full year within the last 3 years for a company that's related to a U.S. entity. So that could be one option. We have the O1, O2 classification, and these are for individuals with extraordinary ability in the sciences, arts, education, and business. And as David mentioned, they have a little bit more flexibility regarding the STEM occupations that could potentially qualify under the O1. There's also the P. There's a whole alphabet of non-immigrant classifications that could be potential options. The P is for international groups or athletes. R is for religious workers. We can do a J potential for scholars, internship. So basically, it's a holistic approach. We generally start with the individual's very detailed resume and look at all of the things that they've gone to school for, maybe have training, certifications, and even hobbies, right, David? We always look at hobbies because they could be, they could be a outstanding juggler back in their home country, and there could be a potential for maybe a P3 for somebody like that. So it's really important to take a look at the individual's full background to see whether there are some other options available.
We also like to ask about family relationships. So for example, if they have a spouse, maybe spouse already has some type of status and we can do a dependent status. So that's something we would explore as well. And we talk about H1B alternatives, but sometimes individuals coming to us for H1B will end up with something else because maybe we were talking about, maybe O is even better option than the H1B. So depending on when the client comes for a consultation, there could be a better option than the H1B because of the lottery. H1B is not ideal. All of those categories that Snehal mentioned, they don't have any deadlines. So we could apply for all those categories at any time during the year. So H1B is really nice. It's a dual intent status. The issue is the lottery. It's pretty much a big issue.
So there are a couple of other ones on the list there that I just quickly want to mention. One is the U, which we discussed when I was talking about individuals who don't have status. U visas are for victims of certain crimes. Those crimes could be domestic violence. It could be aggravated assault. It could be unlawful imprisonment. So obviously, if you're a victim of certain crime, you might be able to apply for a U visa. The nice thing about the U visa is that provision also was recently liberalized to permit for bona fide filings, quick work authorization, and also deferral of removal from the United States. So that's one particular option to keep in mind. Another one is the I visa, which is for foreign media representatives. So for those folks on the webinar who have international connections with international media, I visa holders allow individuals to be in the United States to work for DS, which is duration of status, which is like a student. They don't accrue any unlawful presence if they overstay, but more importantly is that they can be in the United States working while they're continuing to do their thing. Also, J's are for individuals who are trainees or doing research, as we discussed before, and as Snehal had pointed out, J's are also liberalized for those J programs that are associated with green technologies or with STEM. So ultimately, I mean, a couple of really important points that we need to convey to the folks who are on the webinar today. One is, and who are attending the CLE, it's really important to obtain information about the individuals for whom you're doing these visas and to do an upfront analysis and determine whether or not H-1B is truly the best way to go. I mean, maybe H-1B is not necessarily the best way to go. As Snehal pointed out, as Ludka has properly pointed out, it's maybe important to find out a holistic analysis of the individual. What's their academic background? What is their familial background? What is their religious background? And all of these things are important because they all drive particular visa classifications and could potentially drive the individual outside the need to do the H-1B lottery. Sometimes we're very concerned about the fact that a request for evidence might come. And so what we want to do is we want to prepare for a request for evidence in the event that we submit an application or a petition and the government's going to come back to us for further information. So we want to try to avoid that if we can.
So it would be looking at the levels for prevailing wages. For example, that's the thing, that we would prepare definitely regarding the specialty occupation to just make sure that we would be able to respond. More problematic would be when somebody already did registration, and we often see it, David, that they come to us, I've been selected, the individual maybe has bachelor's degree, but it's not related to the position, so that could be more complicated. And that's why it's so important to do the analysis before the H-1b registration, because I mean, H-1b, I mentioned that H-1b registration is really, it made our lives easier, but the issue is that a lot of employers don't really understand the process and they just do the H-1b registrations, and maybe those individuals don't even qualify, and it's not a professional occupation, it's not a specialty occupation. So it is important to start early and just take time and do the analysis about the wage and whether it's a specialty occupation and so on.
And the one thing that I want to add is that if you have a foreign national that you're currently employing or looking to hire who is still a student, maybe has not graduated yet, it's important to know that at the time of this registration, the foreign national does not have to have that bachelor's degree or the master's degree, let's just say, but they do need to have the degree completed at the time of filing. So to go into this initial registration period that is going to be open until March 18, your potential H-1B applicant does not have to have that bachelor's degree. Okay, especially, of course, if they're graduating in May of this year, but they will have to have that degree at the time of filing. And you're eligible to file if you get selected in that first round starting on April 1st. But of course, if your employee doesn't graduate till May, you would wait until they graduate to have that degree and then file your H-1B. And you'll have until June 30th to file that case. And so just don't leave those potential applicants out just because they haven't graduated yet.
That's a really super point. Thank you so much for bringing that up, Snehal. And I've been monitoring the questions, and they've been sort of coming in, and I'd like to sort of bounce some of those questions to you ladies and see whether you have some answers for some of the folks. So first and most importantly, I have an individual who says, I have an H-1B with a not-for-profit that's CAP exempt, okay, but they want to go to a new H-1B employer who's for-profit. Do they have to go back into the lottery? Ludka?
Yes, they will have to go back to the lottery because that nonprofit H1B didn't go through the lottery, so now they would be subject. The only exception would be if they continue working with the nonprofit organization, at least part-time or even full-time, and then they do concurrent H1B with the company that is for-profit. At that point, they don't have to go through the lottery, but otherwise, yes.
Great, thanks. And Snehal, one of the listeners is asking, can I get a job with without going into the lottery at a local hospital?
Well, that would potentially be H-1B CAP exempt, okay, if the job is, number one, is the job a specialty occupation, okay? I'm assuming that, it is. If so, if the hospital is perhaps affiliated with a university or, a not-for-profit organization, 501c, then you could be exempt from the H-1B CAP.
Perfect. And Ludka, another person writes, I have a master's degree from my home country. Does that mean that I can get can I enter the lottery in that 20,000?
Unfortunately, no, it has to be U.S. master's degree and not every U.S. master's degree. That's important. And I've seen a lot of hiccups with that. So if it's a private and for-profit organization, university, it's not going to work.
And so another listener is asking, what are my odds in the lottery? And that's a really good question because that obviously changes from year to year, but at least based on the statistics that we were looking at last year, it appears that individuals who are entering the lottery for the bachelor's or its equivalent, their odds are going to be 1 in 3. So there seemed to be, at least last year, there were 3 registrations for every 1 position. So the odds would be 1 in 3. And for the masters, the US masters level, for the 20,000, those seem to be, the odds are 1 in 1.3. So obviously having the advanced degree clearly gives you a leg up. Now there's another interesting question here. Then that's coming from a medical graduate who's asking, as a foreign medical graduate, if I'm applying for an H-1B, do I have to go into the lottery? Ludka?
So typically would be no. So it depends. It depends.
Right.
If they have J1, and let's say then they go and they do Conrad 30 waiver and they get H-1B, there would be no lottery.
Exactly. They're exempt from the cap. That's right. Great. So those are the questions that I see. I think that brings us to the end of our presentation. And I think we're good. Yeah, unless there are
any questions, we're always available. You can reach us on our website is www.visaserve.com, where you're going to be able to find all of our contact information. And
I just want to point out that the materials for this program included an overview of the H-1B visa process, an H-1B employer checklist, an H-1B employee checklist. Several articles, H-1B articles were included. Also, there's a CAP registration worksheet for your ready reference. And we also included a step-by-step overview of the H-1B process. So those should be disseminated along with the PowerPoint.